Well, okay, first of all, these are two brothers talking, though. So maybe he was approaching his brother not as if he's a former police officer, but I have this information, she's asking for a gun, what do I do with it? And then he turns around and puts on his law enforcement hat and says, come down with me, we need to get a statement on the record on this.
I don't buy that for a second.
Well,
I think that if he went and talked to his brother, yes, they're brothers, but guess what? If you're my sister and you're a cop, and I go to talk to you, I know well that if I'm telling you that I knew of something, of some involvement or something about a case, that you, as being an officer, are going to do something about it. Okay,
well,
so
ultimately, Tyler does go in though and make these statements, and the statements are admitted. And I think it's interesting that even on appeal, these statements. We have a 13-year-old boy here. No parent, no guardian, no lawyer. And even when his mother comes into the room and you have his uncle in the background, I think it was his uncle in the background saying he has the right to an attorney, this is illegal.
Yeah.
The questioning goes on, and those tapes are still the prosecution's key evidence in this case.
That's right.
It's interesting that that's allowed in. What are your thoughts on that? Do you think that that kind of evidence should be allowed in?
Absolutely not. It's extremely disconcerting because
even with your former prosecutor hat?
With my former prosecutor hat, because in New York State, cops know that if someone feels like they're in custody, then you have a duty to read them something that we call Miranda rights. We never see anything about a Miranda, and that if you make a statement as a cop to someone that you know that will elicit potentially a confession or a statement, that you are mandated to give them the Miranda rights.
I think he did have his Miranda rights read to him. Well, I don't think he really at 13 knew what that meant.
But he can't waive them. But that's the whole point. That's what bothers both you and me. Is it waivable by a 13-year-old, by a child? I guess in Mississippi, 13-year-old, well, now we're going to the South. 13-year-old might be an adult. Maybe you could get married at 13. Who knows? But back in the South, at 13, apparently that's a waivable situation here, because in New York, you're a minor, you have to have your parent there, and again, you saw with the confession, the mom goes crazy because she goes in there, she's like, wait a second, you're questioning my child. And if that part got in, by the way, the background noise, I'll call it, of the mom going nuts, the uncle yelling and being kicked out, if they heard that part along with his confession, the jurors, that is extremely damning, because even if you have his confession, you have the background of a mother screaming, you can't talk to my child, this is not what I wanted or expected. And then you have the uncle saying, we want an attorney, what are you doing to this child? Child keeps coming through.
Well, it didn't help him the first time. Don't think you can get married at 13 in Mississippi, but at 13 you can be charged as an adult with murder. All right, as we go to break, we want to update you on today's 13th juror question, the murder. Okay, let's talk a little bit about these false confessions. Why would somebody say they committed a murder when they know what the penalty could potentially be when they didn't do it?
Well, there's a lot of psychiatric studies on this, but just as the legal hat that I just wear today, which is what I have, if you were stuck in a room and you're not given water, you're not given anything to eat, you're not told, and especially if you're a kid, let's make it that I'm a kid now, forget about that I'm an adult. You don't see your parents, where everybody wants their mommy, you don't want to see your parents, and you were in a room and they question you relentlessly, you're scared half to death. You will say after 8 hours, 10 hours, I've gotten cases 10 hours, 12 hours where you're handcuffed to a chair and you sit there and they're hammering at you, when you're a kid, over and over and over again. You will say anything to get a glass of water, to go to the bathroom, to do anything.
It's a form of psychological torture almost.
Absolutely.
I mean, you can clearly see that.
The civil rights violation is
so
what it is.
Now put on that attorney hat a little bit further. Take it to the next step. What do you do when somebody's given a confession, they didn't do the crime, they tell you? How much harder does it make your case when you have a confession on tape or on paper?
That's where you move for suppression hearings. That's where experts come into play. That's why when you and I were talking at breaks, we were talking about were there any psychiatric investigations, mental health evaluations of this particular child of either sex abuse, as well as any other experts in this, be it gun experts, as far as the angle of the shot, who could have done it, how old did you have to be in order to hold that kind of gun, and appropriately so. This is where experts come in, be it for suppression, and if it's let in. Or if he takes the stand, things that are suppressed many times come in. If he takes the stand, then is he a sympathetic person to the jurors that they will want to find him innocent. But again, going back to your original question, if you are locked in a room and you are hammered over and over and over again, and you are and you used it perfectly, it is torture. And you have to get, in this case, you have to get a complete dismissal. If you were in New York, you'd have to get a complete dismissal in order to do a civil rights violation if you were held against your will, not given potentially your Miranda rights, being a minor, getting your parents. You have to have a complete dismissal, not any plea to charge, nothing, a total dismissal in order to go after the state and potentially the police civilly.
All right, well, why do people reveal their embarrassing secrets on TV talk shows? When we come back, we'll hear what you had. Christy Fulgham's brief appearance in this courtroom. She didn't provide any testimony. She really didn't provide anything, but she was, Joanna, a strong visual reminder that this crime didn't go unpunished. There is somebody who is serving time on death row, actually, for this murder, and that to me seems really helpful for the defense.
That's a great point. You want to know why? Because jurors always want to find somebody responsible, especially when you have such a heinous crime, a father of 2 children and a third who's not even his own, taking care of them. They want to find someone responsible for this. And now we look at her. She comes in with chains, clink, 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 coming in. Her arms at first and her legs, then they take it off. You know, usually cops aren't, you don't want them in their uniform. You don't want people in jail gear, because the visual is makes such an impact. And look at it, she goes out. She's going to be coming back. They're going to get some Christy. And this is great because exactly that. Someone has already been found guilty of this. Let the little kid go. He's just a child. That's what they're going to be subtly, you know, Mr. Right. Subliminal. Let him go.
Coupled with the manipulation, coupled with all the testimony that she is the one who had the motive in this case. And it's interesting because when he was tried the first time, his trial happened before hers did, and that time he was convicted.
And she was put on to get in the Montel show, and they're going to see the victim alive and see her talking about him like we talked earlier in the show. Now they're going to be really angry at her, not at the child.
It seems like it's so far a successful, a powerful defense strategy that they've taken up.
Well, now that they got someone who's found guilty of the case, they got someone that this will be working well for them.
Quick question, if there is an acquittal this time around, does that give Tyler grounds for a civil lawsuit? I mean, he spent several years now, 4 years, or a little bit more than that, behind bars for a crime that if he's acquitted of, you know, will he be able to sue the state for that?
If he were in New York and he was found and he was acquitted, which means complete dismissal of the charges, no plea to anything, down to the littlest charge, nothing, 0, then potentially would have a civil rights violation, potentially, depending on the situation, if he was held against his will, held in custody against his will, like we talked about, and sustains damages, injuries to that, and then they would go after the state and potentially the state police, depending on that, and the local police. You go for everybody. Any pocket that was there, they go and hit somebody with that. That's what they would do. Right. So you would hope for an acquittal if I was a defense attorney, and then look to sue everybody afterwards.
Right. In the meantime, acquittal is the #1 objective.
That's my objective, yes.
All right, Joanna Greenwald, thank you so much for joining us today. It is time now to check in with Jack.